families, creating a lifetime of memories. Sadly, some families are denied these important moments due to the sad practice of alienation. These are families divided.
Hello, everyone, and welcome to tonight's episode of Families Divided TV. In tonight's episode, Dean Tong, author, forensic trial consultant, and expert in highly contested child abuse court cases nationally, explains the difference between false and unsubstantiated child abuse investigation reports as determined by Child Protective Services, also known as CPS. He articulates the purpose of minimal facts interviews of children as conducted by CPS and or the police, and then child forensic interviews normally conducted at the Child Advocacy Center or Child Protective Team by specialist forensic interviewers. Dean Tong also is going to cover important topics such as child suggestibility, source monitoring or lack thereof, confirmation bias, coaching, and possible memory source contamination of children's reports or statements, and the impetus these concepts have relative to the overall spontaneity, reliability, and trustworthiness of their alleged abuse disclosures. He addresses child forensic interview methodologies, including the NICHD et al., and why question typology is so essential when child forensic interviews ask kids a bevy of questions on topics that are sensitive in nature. Dean Tong provides anecdotes during his False Allegations for Dummies webinar and hopes attorneys and pro se litigants learn from the same. This is really good. Dean does some excellent sources for us and tells us so much great information. You may want to take notes. Dean's also, I would like to say, is going to be a presenter at our upcoming fall conference on October 5th and 6th. So we're going to be right back with Dean Tong right after these important messages. Hello, everyone. I'm Elaine Cobb. I'm founder and president of Family Access Fighting for Children's Rights. I'm also founder, host, and executive producer of Families Divided TV. I want to invite you to our upcoming fall conference, which is virtual and international. It will be the very last one that we ever have, and it's going to be an incredible 2-day event, and I hope you'll join us. Normally we do the topics, it's just one topic specifically. But this time, I said, you know what, we need to branch it out a little bit. And so I asked you to send in what you thought were very important topics to you. And so that's what we're going to be using and speaking on. We have two keynote speakers. Our first one is Dr. Edward Crook. And he, as a favor to us, we had asked him if he could do a study on grandparents who have never met their grandchildren. And there's never been a study on this. It's always in court or in the legislature if you've had some kind of a relationship with your grandchild. Well, hello, there's many of us out there who have never seen their grandchild, including myself and my husband Chester, who we've never seen our granddaughter Dare, who's now 13. So this is an incredible, extensive study that he's taken over a year to do, and we've recorded it now. And this presentation, I will tell you, is off the chart. It is incredible. It's awesome. I mean, I could just keep going on and on. He's going to give us much information, and he's also going to get this peer reviewed, get it ready to be got out there with lots of different places, and it's going to help. We'll be able to use this in court. We'll be able to use this in the legislature, and it is huge, very, very important. So I hope even those grandparents who have met their grandchildren he's also going to talk to you as well. So you're not going to be left out. So if you are a grandparent, you do not, I repeat, do not want to miss this conference, because this is really, really great. So please, be there. His presentation is entitled The Eraser of Grandparents from Children's Lives. We're going to also have Bill Eddy as our other co-host and our keynote speaker. And he's going to be speaking to us on court trends, the trouble with letting the children decide. Some states and court systems are considering letting children as young as 14 years old have the right to make decisions about whether to have a relationship with one of their parents. He's going to be speaking to us about this. And, Bill Eddy's with High Conflict Institute. He's written numerous books. He's got a new one out now, as you know. And you're not going to want to miss this one. This is a really good one. It's important that we know about all that. We're also going to have Dr. Joshua Coleman, who works with alienated and estranged parents of adult children. And he's very well known out there all over the world. And he's going to be speaking to us about reaching out to your alienated or estranged child, the do's and don'ts that you need to be doing. I get emails all the time from you guys wanting to know, what should I do? Even on our Families Divided comments, I get all that. He's going to let us know right here. So you want to be able to be there for that too. Dr. Sue Kornbluth will be presenting as well in this conference, and she's going to be speaking to us on managing personality disordered co-parents who alienate their children. Now, we haven't done a whole lot on co-parenting. We may have 3, I think, episodes on Families Divided. So this will be huge for those of you that have to co-parent and you're dealing with people who have major personality disorders. So Dr. Kornbluth is going to share much with this on that. And Dr. Mary Alvarez is going to be speaking to us on a very interesting topic. It's going to be called Parental Alienation, the Toxic Stress in Your Child's Brain. And nothing is more important than our child and what they're going through this. They are what matters through all of this in the world of alienation. As we know, alienation is child abuse. And she's going to share some very interesting things. She's done a great study on this, so you're not going to want to miss that. Chris Turner is going to be speaking to us on trusting and understanding agents of court guardian ad litem, amicus therapists, psychologists, parenting facilitators, and court-appointed professionals. She's going to tell you, give us some information because it can get really overwhelming to us as we have to deal with these people. She's going to give us some great advice on that as well. And then Dr. Kelly Baker is going to be speaking to us on the therapeutic interventions for parent-child contact problems with teens. We've never, and I'm sad to say that, we've never done anything with teens. So this one's going to be huge. And Dr. Baker's really doing an intense study on it, and it is going to be good, but it's really going to help you as an alienated or targeted parent and how to deal with this with your teenager. We also have Melanie Gill with us, and she's going to be speaking on Liar, Liar, Pants on Fire. We deal with a lot of this in court with lots of things that are said that are not true. And, Melanie's really been through the mill over there, so to speak, in the UK. And she's going to be helping us in sorting out this important info. Also, Dr. Kathleen Ray from Canada will be speaking to us on understanding the realities of a reunification program, dispelling common misconceptions. There's a lot of lies and fake news out there on this, and she's going to share and help us to understand what is factual and what is false. And so you don't want to miss this one either. Then Attorney Chris Turner will be with us. He's going to be sharing secrets to litigating parental alienation allegations. Chris is one of the best attorneys, and I've dealt with many over the 13 years, and he truly is like at the top for me. He really cares about you guys, and first and foremost, he cares about you. And he's, a lot of attorneys, I've got to say, sadly, are out for the bucks, but Chris isn't one of them. And he's going to be sharing a lot with us on this, so please don't miss out on it. Also, Randy Fine is going to be speaking to us about confronting the mirror. Do narcissists face their own reflections? That is a very interesting question, and Randy will be sharing with us on that. Also, we have with us Dean Tong. He has a really great presentation on false allegations of abuse, navigating the three-ring circus. And he's really, really knowledgeable on all of this and dealing with CPS and all of them. So he'll share much info for you and how to deal with all of that. And then, to me, this is really the most important part of the conference, I think. Caden's Law has pretty much destroyed or tried to destroy our families. Well, we're going to have with us Dr. Lynn Steinberg, Yakov Achamam, and Robert Gaza with us. And those three are going to be doing a panel discussion. And they all three have all different perspectives on all about Caden's Law and what to do and how we can go around it and how we can defeat it and help get our families back together in ways that we can. Many of you in states really need to be paying attention to this. I'm going to tell you that as a parent and as a grandparent, if we don't stand up and fight for our children and our grandchildren, we can just about wrap it up and forget about it. So you can't sit back and say, oh, I wish they'd come help us over here and all that. Get up and get it done. Help everybody. You don't have to be, a college degree or any of that. You've just got to have the heart and the zeal that you want to get up and fight for your own kid and your own grandkid. So be a part, make it happen, and come and learn from this. You can submit your questions, and we're going to have questions for all different presentations and especially for this. So we want you to do that. So don't miss out on that, please. That's going to be really important. I also want to emphasize that this will only be, again, through only the Zoom, Family Access Zoom. That will be the only way you can be a part of this 2-day event. But I also want you to know, and this is very important, if you cannot make the 2-day event, that's fine. We'd love for you to be there in person, but we understand everybody's lives are busy. So take the time and register, and you have between that following Monday, the 7th of October, till the end of December to view it. We'll have that for you available. And here's the secret. If you do register and you do come to the event, you can watch it as many times as you want. So that's going to be a special that I'm giving my gift to you that way, because this will be our absolute last conference that we ever have. So you will have plenty of time to view it as many times as you want. And I hope you will take advantage of it and do just that, because we feel like these topics are so very important. And we want you to be a part of it. We're also on Sunday night, we're going to be having, after the conference, we're going to have from 7 to 9, a time where you can meet together and share your testimonies. If you want to share your stories and stuff, that's fine. And we're also going to be making a support group out of that as well. So come for that. And then on Saturday night from 9 p.m. until 7 a.m. Sunday morning, we're going to be having what we call the one-on-one chat room, which I lovingly call the Chatty Cathy group. These people have a great time at these. We've done these every international virtual conference. They get together, and I do not understand how in the world they can chat half the night online and get back in the morning for the conference, but they're doing it. But it's a great time to really open your heart, share your experiences, give each other ideas on what's important to you. We do everything we can to make this the best it can be for you and being supportive to you. I really hope that you will come and you will join us for this very important, incredible event. And also, I will be announcing to you something very special at the end of our conference. So please come, please register. You've still got time, and look forward to seeing you there. Take care. God bless.
Divorce and co-parenting are a major life interruption for families, especially the kids, but also for parents and grandparents. And it's even worse in blame-filled, high-conflict cases. When parents engage in alienation by turning the kids against the other parent or grandparents, kids suffer. They're denied the opportunity to build the 4 big skills necessary for future resilience. New Ways for Families online class can help. Parents learn to use our popular BIF and EAR skills to calm the conflict and stop the hostile emails and texts. And we even have a class for kids and parents to learn together. Research shows a 75% improvement in joint parental decision-making after this course is taken, plus overall improvements for kids' well-being. Don't wait to make this affordable investment in your children's future and improve your well-being too. Start learning new ways for your family today at conflictplaybook.com.
Hello and welcome back. And I want to thank Elaine Cobb and Families Divided TV for having me back. I think this is the 4th talk I've given on behalf of her organization, which is an organization that obviously recognizes parental alienation, mental, emotional, psychological child abuse. Today's talk is false allegations for dummies. I'm going to premise that by saying that most of these allegations are not false, and you good folks out there are not dummies. With that said, I thought it was a catchy title talk based on the Dummies published book series published by IDG and Wiley. Let me say that when you are falsely or wrongly accused of abuse, and that could be sexual abuse, it could be physical abuse, it could be emotional abuse, it could be medical abuse, shaken baby syndrome, it could be Munchausen by proxy, which is now known as factitious disorder upon another. It could be false allegations of coaching, which oftentimes may affect the mother who could lose custody. It's not what you know, it's not what you think you know, it's what you can prove. And in these cases, unfortunately, as my website has articulated since 1997, abuseexcuse.com, you, the accused, are presumed guilty. And unfortunately, you are forced to prove a negative and forced you're not the monster that the state or the government or CPS or your ex is paying you to be. With that said, you could be falsely accused of abuse or wrongly accused of abuse and wind up in 5 different court venues or jurisdictions. Those venues or jurisdictions are the following: criminal court, where the evidence threshold on the state to prove you guilty is beyond a reasonable doubt. That number is about 95%. It's a very high burden. But because most of these cases are he said, she said, what a child said, and lack forensic medical proof, based on hearsay, rest just stay out of court statements made for the truth of the matter asserted, it's not that difficult for the state to reach that burden. And I'm a great anecdotal case in that, because while I am successful in many of my cases, I do have clients in prison. The next court is juvenile court. Okay, that's the court where CPS summons you to court. They can take your child based on imminent risk of harm. They can file for dependency, which means they're trying to get a judge to find you are abusive, neglectful, or have abandoned your child. And it can even escalate to termination of your parental rights. Okay, there are usually two different burdens approved there. The first burden on dependency, which is the first stage, is preponderance of evidence. CPS only needs 51% more evidence than not to find that you abused, neglected, or abandoned your child at a juvenile court, what's called adjudicatory or evidentiary trial. And if you lose that hearing or trial, CPS can force you to sign a case plan, hoops that you'll have to jump through. Those hoops will last 1 year, where you will be afforded 2 judicial review hearings, one every 6 months, to substantially comply that you have jumped through those hoops. If you did not substantially comply with that case plan, a judge can order a TPR, termination of your parental rights, at that hearing or trial. Second trial or hearing, the evidence threshold escalates to 75%. Clear and convincing evidence is the evidence threshold for CPS there. In some states, it's clear and convincing at both levels, both the dependency and the TPR proceeding. So there's a lot hanging in the balance here with you and your children and your family. The third court would be, of course, family court, petitioner versus respondent, where parenting time, divorce, obviously, parenting time, custody comes into play. And those cases are all adjudicated at 51%, a preponderance of evidence, more evidence than not. Credibility, who's more believable to the court, is decided by the court. The ultimate issue at bar, whether you're abusive or neglectful in a family court proceeding, or whether you're committing alienation, psychological abuse of the child, maliciously or non-maliciously, estranging the child away from the opposing parent, that's all up to the judge. The judge basically decides as a trier and finder of fact there. The two other courts you could wind up in, injunction court, restraining order court. Again, the burden of proof is 51%, a preponderance of evidence. Here, you don't need false allegations of child abuse. It could be just domestic abuse, where your wife or girlfriend, intimate partner, accuses you of a statement of threatened harm. She's in fear for her bodily safety. Perhaps she has a child from another relationship, and she is threatened. She's scared for her child as well from the accused. So she'll go down to the domestic violence shelter or the courthouse and try to secure a restraining order, an injunction based on an affidavit that she completes. And again, that is 51% preponderance of evidence, more evidence than not. And if a judge finds that the complainant is clearly in imminent danger, that restraining order will be granted, and the accused will be issued no contact. That no contact could be against the child, could be against the complainant, the adult, or both. If you violate that injunction, you will get your day in court about 10 days later to basically, again, prove a negative, lies, mistakes, whatever, or evidence that you have to impeach the allegations of the complainant. At that point, you'll get your day in court. And then if you violate that restraining order, it becomes a criminal infraction. You can be arrested. And that means any contact whatsoever. If you bump into the complainant at the grocery store, in church, if you email, if you text, anything like that, that is revealed to the police, the authorities, as a violation of that civil restraining order, that becomes a criminal sanction, and you can be picked up and arrested anywhere for the same. So, very serious. And then, of course, the last process of court venue jurisdiction is called administrative court, where the Child Protective Services places your name on the child abuse registry. I, as an expert, have testified in many of these administrative law judge hearings in several states. Again, the burden of proof is preponderance of evidence, more evidence than not. In these cases, if you are a mandated reporter, such as a doctor or a nurse or a teacher, it will kill your occupation in a New York minute unless you successfully have a hearing in front of that ALJ, administrative law judge, and force the judge, through evidence, of course, to basically amend the finding from substantiated or verified, whatever CPS classified it to be, back to unfounded or unsubstantiated. And even if you're not a mandated reporter, just a layperson, a construction worker, whatever you do in life, you will remain in the CPS database for your state for a long time. So it's that negative stigma that you will have, everybody will have, unless you compel a hearing and successfully litigate that hearing to get the administrative law judge to hurdle back that finding. Oftentimes, it may require someone like myself, an expert or a psychologist or psychiatrist, testifying to basically back up, your side of the story. If it's based on sex abuse, on hearsay, that the complaining child's outcry was perhaps mistaken memories based on memory source contamination, suggestibility, coaching, whatever the case may be. You'll need an expert to go over the forensic interview of the child, which is captured on DVD, to basically articulate to the administrative law judge the methodology used by the forensic interviewer, whether it was the NICHD, which is, of course, the one that I learned and trained under with my retired colleague, Dr. Phil Esplin, who was the original co-author of the NICHD back in 2000, or whether the CPS child forensic interviewer person used the National Children's Alliance method, the APSAC method. Down here in Florida, oftentimes they use the radar method. These are semi-structured models that are allowed to use leading, suggestive, repeated, direct, forced choice questions that contain negative stereotype induction, vilification of the accused, and it's easier for the child's contextual memory to be contaminated here. And basically the details, obviously they're looking for details. And if the interviewer is putting words or thoughts or ideas in the mind and mouth of the child, that is your Achilles heel. Because if the child implicates you during that forensic interview, you could be arrested. You could wind up in juvenile court. Obviously, it can be used against you in family court. And this became known anecdotally in my world, as I went through this 40 years ago in the 80s, as the three-ring circus: criminal, juvenile, and family court. All three venues at once, at the same time. Good luck on finding an attorney who can help you litigate through all three venues against the state, counsel for the state, the district attorney's office, a counsel for CPS, counsel for your ex and family court. It becomes rather overwhelming rather quickly. Not to change the subject, but for those of you who do need a good lawyer, there is a section of my website, How to Choose Your Attorney. There's a section of my book, Elusive Innocence, by the same title, How to Choose Your Attorney. I do recommend everybody go to avvo.com to check the reviews of any lawyer who they're thinking of hiring, or even who they have hired. Because maybe you've hired that lawyer and a couple of months have gone by and you haven't seen any aggressive posture by your defense counsel, and you pay that lawyer a hefty retainer fee, and you come to find out the attorney's playing the let's wait and see what happens game. So you do need a structured plan of attack. You do need an aggressive attack. You don't want to sit back, and be reactive. You want to be proactive. Think outside the box. Think unconventionally. In these cases, you may be a father's rights guy, and you may be on Facebook a lot in different groups, and you've heard of false allegations being called the silver bullet. Well, I'm here to tell you that there is no silver bullet. Okay. There's no published studies, empirical, peer-reviewed scientific journal studies, articles on the silver bullet. The silver bullet has never passed a Frye or Darvard challenge in a court of law as being bona fide science that is basically accepted by the general scientific psychological community, science that has attained statistical and clinical significance, science that has been replicated. That doesn't exist. This is a term concocted by the father's rights guys. It's a catchy term, right? And basically, you walk into court and you want your lawyer to champion to the judge that you've been falsely accused by the silver bullet. Well, It doesn't exist. Okay. And with that said, you know, I'm going to cite a study from 1990 by Fennis and Jaden, which was published in the journal Child Abuse and Neglect, which was the original study that showed that only 2 to 5% of these allegations of abuse, child abuse, are made with malicious intent, that are premeditated with malice of forethought, made in bad faith, that are considered false. Okay. That's false. Malicious coaching of a child to falsely accuse another parent of abuse, child abuse, is a false allegation. You know, case in point, I had a case I was assisting in 2013 in California, and the CPS came to the mother's door, and the CPS worker wanted to see the child, and the child came to the door with the mother. They opened the door, and the mother pointed her index finger to the child's forehead and said to the child, "Now you remember what I told you to tell this lady." So obviously that was a case of malicious coaching, right? And so CPS actually confirmed in their finding that this was a false allegation, and the judge abdicated to the CPS worker in court and basically stated on the record that this was a false allegation. But I'm here to tell you that most of these cases are not false. Most of these cases are errors, what we call in psychology source misattribution errors. And those source misattribution errors means basically you're misattributing the origin or source of the alleged abuse, something else besides. And because it may be something else besides, it probably says you did not conduct what's called source monitoring. Source monitoring means you are vetting the allegations, you are exploring for alternative hypotheses. How else could this have come to fruition? Why else would the kid be saying what the kid is saying unless it's true? You know, the old operating maxim held by CPS. This is how these people are trained, okay? They are well-meaning, well-intentioned workers out there. And some are very competent, but some are misguided. And so, you know, that maxim is that children don't lie. Children are not mistaken about sexual assault. They must be believed and protected at all costs. Well, you know, there's another side to this, and the side is the side of due process, right? The side where the accused said, I didn't do this. This never happened. And the child says it did happen. And the child states to a forensic interviewer, capturing on a DVD, that it did happen. And that is your smoking gun, I can assure you. If the child implicates the accused at that forensic interview at the Child Advocacy Center, which is observed by usually a detective and a CPS worker in an observation room, and the child implicates the accused in a bad private part touch, or it's a case of alleged physical abuse, and the child claims she or he was hit or smacked or whacked, you know, on areas of the body that the child shouldn't have been, you know, and I'm not telling parents how to raise their kids, but, you know, if you're going to spank your kids, I suggest you do that with an open hand to the buttocks and follow that up with a hug. The reason you follow that up with a hug is that's the last thing the kid recalls, is that hug, not the slap or hit to the buttocks. Don't use a switch. Don't use a coat hanger. Don't use a cord. And let me tell you, there doesn't need to be medical evidence here. There doesn't need to be a doctor who gives an opinion to reasonable and medical certainty the child suffered a hematoma or ecchymoses, you know, or there were welts or bruises or marks that supported the child's allegation. None of that needs to be present. Just like in most of these sex cases, 95% of child sex cases, these are hearsay cases. He said, she said, what a child said, no medical forensic proof, okay? The sex abuse nurse examiner or the advanced practical registered nurse may give an opinion that the child's statement or history or disclosure is consistent with sexual abuse, or that it neither negates nor confirms sexual abuse. Either or puts the accused up against a potential Achilles heel. okay, you've got to now possibly impeach that nurse examiner who's a medical profession. So you're going to have to get a defense forensic pediatrician, trauma expert, who's basically done gynecological anogenital rape exams on children, and be able to give a matching opinion that counters the state's expert. Okay, these cases can morph and escalate to a battle of the experts, where obviously that can get expensive. I've said this dozens of times before. If you are faced off in a juvenile court proceeding, facing dependency and or TPR and or a criminal case, and you cannot afford the services of a retained attorney or expert, you have a legal right to champion, after you are deemed indigent for costs, or informa pauperis, as it's called in the law, the right to have the court approve your attorney and expert to be paid by the state. So it won't cost you or your family any money whatsoever. But I don't believe, I'm not a lawyer, but I don't believe that what I'm telling you applies to family court. In family court, I'm sorry to say, you get as much justice as you can afford. And that's the way it is in this country. And so these cases are highly contentious. Obviously, I talk about SAID, SAID, in my book, Elusive Innocence, Chapter 8, Sexual Allegations in Divorce. This is science, okay? This goes back to 1987, published in the journal Conciliation Courts Review by psychologists Blush and Ross out of Michigan. Okay, they did a study on the factors, including the timing prevalent that comes to fruition with these child sex abuse cases with younger children, precocious children, suggestible children, certainly children who are old enough to lie, old enough to give salient details of molestation, but old enough to lie, and clearly old enough to make mistakes, right? And so they did this study, and they found that a very high percentage of these cases, these said cases, were unsubstantiated, and some were false. And this was published in the New York Times. And the study by Blush and Ross was further replicated by Trochme and Bala out of Canada, Dr. McKay in the UK, in England. So there is science to SAID, SAID, the SAID syndrome. There is no science to the silver bullet. Okay, you can flip it around as a term that's convenient to use, but I suggest your attorney not use that term in court. You'd be better off using the term, "We have a smoking gun, Your Honor." Again, it's not what you know; it's what you can prove. So, save all your emails, your posts to social media, your text messages, messages at a parenting app, OFW, Talking Parents, app close. Save all those communications, because one day you may need them. They potentially could be legally admissible in a court of law to back you that the accuser had motive, method, means, and opportunity to ruin your life. And so most of these cases are not going to be cases where the accuser is calling 1-800-96-ABUSE, which is the toll-free hotline in my state of Florida, in Tallahassee, to ruin your life in a New York minute by calling that you've abused the kid. And we used to have what's called the B.J. Cossin warning here in Florida, where you had to tell the worker, the dispatch worker over the phone, whether you were involved in a highly contentious divorce, parenting time case, or custody case, when this allegation you're making is consistent with that. So they had to know that information. I don't know that they have that still on the books, B.J. Cossin warning. I don't think so. But I can tell you this, in my state of Florida, it is a felony, punishable by 5 years in prison, third-degree felony, if you maliciously, falsely accuse someone of child abuse in the state of Florida. There are only a handful of states that make it a felony to falsely accuse somebody of child abuse in America. Most of the states it's a misdemeanor. Most of the states it is a slap on the wrist. And so, I do urge you people to be proactive, develop a structured plan of attack, a methodical plan of attack, strategy, theory with your attorney early on. Obviously, if you've been arrested or you're under criminal investigation for child abuse, don't answer your phone from private, unavailable, or restricted. That probably will be the authorities. And they're looking to do a confrontational pretext, precept, or prearranged controlled phone call with you. They're trying to get you to cough up a confession. So don't answer your phone. If you're under investigation for child abuse and you know you are, do not answer your cell phone from those three types of numbers that could come in. Don't talk to the police or CPS without counsel present. And a lot of people have nothing to hide. They will give their blood, their bodily fluids, take a polygraph. No, don't go there. Okay. With all due respect, you're not a lawyer. You're not an expert. You don't know the rules of court, the rules of evidence, the rules of procedure. Stay on the sidelines. Okay. Let your professionals handle the case for you. It's in your best interest. It's in your children's best interest. I think that's all I have for today. I will be back again. Thanks to Elaine Cobb and Families Divided TV for having me. And you all be safe and be well.
In our next Families Divided episode, Sally Harris speaks about healing from within, the transformative power of self-forgiveness.